Good morning, Sonny, and thank you so much for the opportunity to share some perspectives. I'm going to ask Samuel Eckman to also turn his camera on and unmute himself, and we'll get started here. Excellent. Good morning.
Morning, Scott.
Thank you so much for joining us this morning, and my apologies, an airplane is flying directly overhead right now. Don't know if you can hear it, but it's making it hard for me to hear much of anything. My name is Scott Shapiro. I'm the managing partner at Downey Brand. We're a regional law firm in Northern California, and other than a managing role at my law firm, 100% of my time is spent helping local agencies with flood risk reduction or flood protection or flood control issues. And over the last number of years, just as Mark and Sonny has talked about, the reality is that homelessness is significantly affecting our operations. As an attorney, I have seen the case of City of Boise cited many times by people on all sides of various issues relating to homelessness. And in that, I've realized that the case doesn't quite say what people says it says. And so the purpose of this first panel is to have a conversation with Samuel, who will talk a little bit about the case itself and provide some details. I want to be clear that no matter what the case says, I think we all agree that homelessness is a significant issue. It is a significant issue on one side, affecting our ability to provide effective flood protection, and it's a significant issue on the other side, affecting our society in devastating ways and affecting the individuals who are homeless in even more devastating ways. So the purpose of this conversation that we're going to have now is not in any way to minimize what the issues are associated with homelessness. Rather, it is to set a legal foundation for you to understand what the court said and what the legal restrictions are as you work through what your approach will be in your community. So I'm really blessed today to have a chance to have this conversation with Samuel Eckman. He's an associate in the Los Angeles office of Gibson, Dunn, and Crutcher, where he is a member of the firm's appellate and constitutional law and class actions practice group. He has litigated a number of cases in the U.S. Supreme Court and courts of appeals, and he's here today in particular because of his work on the City of Boise versus Martin. Before joining the firm, Mr. Eckman served as a law clerk to the Honorable Antonin Scalia of the Supreme Court. He also has clerked for Honorable Alex Kaczynski, then Chief Justice of the U.S. Court of Appeals for the Ninth Circuit. He graduated with high honors from the University of Chicago Law School in 2013. While he was there, he served as editor-in-chief of the University of Chicago Law Review. For those of you who are not lawyers, let me just tell you that's an impressive pedigree and really makes him amongst one of the most qualified lawyers that I've had a chance to have a conversation with. So again, Samuel, thank you for joining us this morning. What I'd appreciate if you could do is to maybe chat for a few minutes about what led up to the case, what your role was, and maybe not quite get to the conclusion of the case, but set the stage for us about what was going on and what the court was asked to deal with.
Sure. So the City of Boise had passed two ordinances designed to deal with the growing problem of homelessness in their city. The two ordinances that were at stake here were the camping ordinance, which made it impermissible to camp in public, which is defined pretty broadly as sleeping, being outside, resting in a public place. The other one was a disorderly conduct ordinance, which made it impermissible to sleep in public on private property without the permission of either the owner or the person in possession of the property. The city had been going through a bit of a back and forth with local advocates and homeless communities to enforce it in a way that made sense, that balanced the competing interests. For example, they instituted an amendment to the ordinance in 2014 during the course of the Martin litigation that made clear that they would not enforce the ordinance when there was no shelter space available. That did not ultimately prove relevant for reasons we can get into. But really what the city was focused on with these ordinances was, one, maintaining public safety and public access to areas like parks, to public utilities and facilities, and two, protecting the homeless populations themselves. There were a number of problems coming up in the Boise area with drugs, with violence, with sexual assault in these homeless encampments. And it's very difficult to police them, not to mention issues of public sanitation, both at large and within those communities, as we've seen in the past year with the coronavirus pandemic. So it was focused really on those two issues: one, maintaining the broader city facilities, and two, making sure that people who were homeless were getting into places where they could be cared for, where they could have access to mental health services, to substance abuse recovery services, and to just get out of the cold. And this was sort of a carrot and stick approach. The quote unquote criminal punishments that went along with these ordinances was a $25 to $50 fine. So this wasn't any sort of, locking the door and throwing away the keys sort of an issue, but it was designed to just provide a little bit of an incentive to make sure people were getting inside and out of the elements and leaving public spaces open for the public to use.
Thank you. So I wanted to share with you and with our participants today a little bit of a quote that I found in an article published by the Harvard Law Review on the case. And I think maybe this is a good start for you describing what you think the case stands for. The quote says, "Did Martin protect homeless people or preclude democratic politics? On closer inspection, the case neither nullified the range of laws that punish homeless people, nor prevented the political process from addressing the serious societal concern of homelessness." It sounds a little bit like the Harvard Law Review is commenting, saying the case didn't do much. So with that perspective from the Harvard Law Review, I'd be curious for you to run through the case, a little bit of the procedure, and what you think the court's ruling says and what it stands for.
Yeah, I think that's right. I think that this is one of those issues, and this is, I think, my third opportunity to speak to public officials and policymakers about the implications of the decision. And I think it tends to be overstated in what it means for practical governance. The real import of the decision was that it extended the Eighth Amendment's cruel and unusual punishment clause in a way that it has not really been applied in the past. Matters to lawyers, matters to legal theorists, interesting intellectual question, and in the day-to-day running of a city or county, the court left a lot open to deal with this problem of homelessness. Traditionally speaking, the cruel and unusual punishment clause, which is what this claim was brought under, these were homeless individuals who sued the city saying that barring camping or sleeping outside when there's no other space available is essentially cruel and unusual punishment because, look, we have nowhere else to go. Ordinarily, the cruel and unusual punishment clause has been understood only to focus on types of punishment through two types of rules. One is categorical rules. This is, you can't use medieval torture, punishment, things like that. You can't cut off a thief's hand. You can't brand someone with a hot iron, no matter what they did. The other rule is proportionality rules, which say that you can impose certain punishments, but only if it's proportional to the underlying crime that's charged. The death penalty is the classic example here. The court has said repeatedly it's constitutional, but you can only impose it for, under current jurisprudence, homicide crime. So anything less than a homicide, the death penalty cannot be imposed. The Ninth Circuit in this case went a step farther and said that it actually prohibits any type of penalty, no matter how minor. As I said here, we were dealing with $25 to $50 fines if the conduct is deemed not voluntary. The case built on two Supreme Court cases from the 1960s. The first was Robinson v. California, which struck down a California statute that made it a crime to be addicted to narcotics in the state of California. The court in that case had said that you're not punishing any conduct at all. You're punishing the status of being addicted to narcotics, which could come about in completely innocent ways, people who develop a dependency after prescription drugs, or through conduct that's committed outside the state in which the state doesn't have any legal authority to punish if you become addicted in a different place and then come into California. So that was a fairly minor case in the broader sweep of the case law. But then a few years later, in the case of Powell, which came out of Texas, the court considered a law against public drunkenness And it created a 4-1-4 split, meaning there was no majority. You had 4 justices in the plurality who said that this public drunkenness law was no problem at all because it prohibited conduct, being drunk in public, not being drunk writ large. There were 4 justices in the minority that said this is Robinson outlawed criminalizing status, but involuntary conduct is essentially inseparable from status. And public drunkenness is often a result of 1, homelessness, and 2, addiction. And therefore, even though it's focused on conduct nominally, being drunk in public, drinking in public, it violates the cruel and unusual punishment clause to the extent that the conduct is not really voluntary on the part of the people who do it. And then the ultimate dispositive vote came from Justice White, who said, well, I don't know, maybe the dissent is right writ large, but in this particular case, this particular plaintiff had a home, he had somewhere to go, he was not in public involuntarily, he was not homeless. And so whatever the broader legal rule might be, it's not implicated here. The Ninth Circuit built upon the dissent and Justice White's sort of dicta in the case to say that involuntary conduct might well be impermissible, but then it left a lot of ground open for what really constitutes involuntary conduct and where on the margins are cities and localities allowed to limit and direct laws against public encampments.
Thank you for that explanation. So I'm going to ask a few more questions, but I'm also going to invite our participants who may have questions to type those into probably the chat or the Q&A, whatever the best way is. I know I'm seeing the chat that people are typing into panelists. And so if you want to send one through the chat to me, I can read that to Samuel as we continue on. But I'd love an opportunity to open this up after I ask a few more questions. So Samuel, if you were hired by one of the public agencies online today, and you were asked to draft an ordinance which would help them keep their facilities protected, I think you understand from our previous conversation that if, for example, you have a levee and there's someone sleeping on it, it makes it hard to inspect that levee. In addition, someone sleeping in a waterway puts that person at risk because a flash flood could come through in some of the areas that NAFSMA represents. We have examples of homeless folks who have been sleeping on a levee, find it not to be level, and so they try to level it out, and they level out the slope, and in the process, they cause structural harm to the levee. So if any of these folks wanted to draft an ordinance that would restrict the homelessness's ability to affect these flood control structures, how would you advise them to draft that ordinance?
Yeah, that's a good question. And I guess to start, I'll say the decision in Boise addressed this to some extent in a footnote stating, and I'll just quote it in full here, even where shelter is unavailable, an ordinance prohibiting sitting, lying, or sleeping outside at particular times or in particular locations might well be constitutionally permissible. So too might an ordinance barring the obstruction of public rights of way or the erection of certain structures. So as we mentioned at the top, the ordinances in Boise prohibited public camping anywhere. There are pretty much 3 situations where the Boise decision won't come into play then. One is where you aren't imposing criminal punishments at all. So for example, you just use move along orders, you prohibit camping, but you're not actually prosecuting people criminally for violating it. You'll send the police by a few times a day saying, look, you got to move along, you can't stay here, it's a public issue. So when there's no criminal punishments, you're okay. 2, when there are other places to go, I know in California, including where I live, cities have opened up public parking lots or public facilities, even outdoors, with some porta potties, with hand wash stations and things like that, and said, look, this is the place in the city. If you're homeless, you can go stay here. We'll put security around. We'll have facilities, but you can't just camp anywhere. You got to be in one of these designated locations if you're going to be camping outside here. And 3, would be to make sure that anything you're imposing is going to be with sufficient clarity and minimizing discretion. I think a lot of the time cities get into trouble is when they're sort of imposing pretty vague restrictions on public camping that then get implemented in an ad hoc way, which tends to lead to litigation where people feel like that's not being imposed in a very predictable way for the homeless, especially keeping in mind that these homeless people don't have access to, the newspapers to know how exactly these things are being implemented. So clarity is always going to be key there. I guess the takeaway is if you're drafting an ordinance or if you're interested in dealing with maintaining public facilities in a city or town, to focus on narrowness, making sure that any prohibitions on public camping are limited to areas where it does serve a true public access or public interest and isn't too broad. So there are places that people can go, even if they're still outside. It doesn't have to be an indoor shelter necessarily. And that it's being imposed in a narrow and clear way for those who will be affected by it.
Some of the people I've talked with about these ordinances have said, well, there needs to be some teeth to it. Without teeth, you just have the police asking people to move, and they may decline to move at all. You said that the criminal penalty, the $25 fine, for example, is a clear problem. Is there a difference between a criminal penalty and a civil penalty in this context, or are civil penalties similarly problematic?
I do think civil penalties can prove a little problematic when you're dealing with homeless individuals. I think the courts will tend to look at even small or minor fees or anything like that as raising issues where the people who are affected are indigent and typically won't be able to pay them. So you do run into a problem with those teeth. That being said, the cities that I'm familiar with that have opened up these parking lots and things like that, designated camping areas for the homeless, haven't run into too many problems with enforcement. People will go there. It's just a matter of making sure, going through the public spaces and making sure that you have the police going around and ordering them to move along.
So I don't know if this issue came up in City of Boise or if you've been exposed to it, but here in our area in Northern California, one of the significant issues that has come up are all of the belongings from the homeless. And we have talked with various cities and counties in the state and tried to develop ordinances that would allow us some level of ability to move folks along. And one of the responses that comes back is, well, when you tell people to leave the facility, to leave the levee, and they have all these belongings, they don't always have the ability to move all those belongings that they've accumulated over several weeks and place there. And then they try to shift the responsibility to move or hold on to those belongings to the public agency, saying the public agency needs to store them until the homeless person can come and get it. Did that issue come up in Boise, and do you have any perspective on the relationship of personal property to the ability of government to restrict people's ability to be in public places?
That issue didn't come up in Boise, but it has come up in a number of other cases. And that's one limitation of the Boise decision. As I said, it's an Eighth Amendment case that doesn't sweep too broadly in terms of practical governance. But a lot of times you'll see other claims brought alongside those claims under the Eighth Amendment in Martin. I want to draw attention to one because it's of relevance here. It's Bush v. City of Marysville, in which a city in the Eastern District of California ordered people to leave an encampment due to a threat of flooding. The plaintiffs, homeless individuals, attempted to return after the floodwaters receded, and the city said, look, under threat of arrest, look, you can't come back here. It's just completely destroyed. There's risk of further flooding. And they ended up just bulldozing the encampment. The court, it was a district court in the Ninth Circuit, held that there was no Eighth Amendment violation under Martin because the threat of arrest was pursuant to the city's enforcement of not of a criminal ordinance designed to punish, but to a legitimate attempt to keep people out of an already flooded area. And however, while there was no violation under Martin, the court held that there was a possible takings claim because the city had just bulldozed the property, the encampment, along with all the people's materials in there, all of their personal property. In addressing this, there's not much from the appellate courts outlining clear rules on this. It tends to be handled in the lower courts. the courts tend to look somewhat skeptically on rules that seem to be imposing forfeitures where people have really no choice but to take their property elsewhere. LA has had some bad decisions on this where, rules against having milk crates out on the sidewalk and things like that have been struck down, typically through settlement ultimately. But I think, again, the judges that we've dealt with have tended to view this through a practical lens and recognizing the need for some latitude for policymakers to deal with these problems of homelessness. And so when it's not seen as pretty much something that's impossible for people to comply with, they tend to be pretty forgiving of cities.
Let's pivot on that case you just mentioned. Was it Marysville? I think that was the name you said.
That should be City of Marysville, yeah.
Yeah. And in that particular case, you said that the court found that it was legitimate for the city to keep folks out of that area because of a risk of flooding. We have a question that came in from Scott Schlief. He writes, given that municipalities are aware of which areas flood and have often designated areas to hold and convey those waters, what are the legal obligations that municipalities have to remove individuals from flood-prone areas? Is there culpability if they fail to inform unhoused populations about the dangers of camping there or fail to remove them from those areas? It's a little bit outside of the case, but I certainly have a perspective practicing law for 27 and a half years, but curious if we could start off with your perspective on that issue of potential liability for public agencies for not moving people.
That is a good question. And this is where, public officials tend to be put into something of a bind. I think that if, just going back to general legal principles, if this is a result of affirmative conduct undertaken by the city to create these flood areas where they've directed these waters in this way and where they have a knowledge of it, there's probably at least an obligation, or would at least be wise, to warn homeless populations of that fact. This is a floodplain. This is an area that's prone to flooding, by posting notices and things along those lines. As to affirmatively moving them or providing alternative space, I would think probably a court would say, look, if you know that people can't camp here, that can't be where you're designating as a camping place because it's, dangerous. But as to an affirmative obligation to move people out, I would think as long as there's warnings and that people have notice of the implications, there's probably not legal liability there. But Scott, I say this without having done a lot of research into this, and it's obviously going to change a little bit by jurisdiction as well.
Yeah, I agree with your analysis. Here in California, we have a statute called Dangerous Condition of Properties. And that statute is set up to say that a government agency can be liable when someone is harmed as a result of property owned by the government, where it was considered to be in dangerous condition, where the average person might get hurt, where the government agency knew that that could happen. The government agency didn't notify anybody of the risk and didn't act in a reasonable way to try to reduce the risk. And so I agree that as a general matter, yes, public agencies could be liable, but that liability is likely attenuated or eliminated by acting reasonably, by, as you said, posting signs that this area is subject to flood risk, by informing people, by supporting people in their ability to move out of there. I will note that that is going to be a question specific to each state in this country. There probably isn't a federal statute that applies on that issue. And so I don't want any of you to take legal advice from Samuel and I being licensed in California, elsewhere in the country. But as a general matter, across the states, you'll see similar statutes designed to say that as long as the government's acting reasonably, doing its best and notifying people of a risk, it would typically not be culpable in a situation like that. I encourage other people to continue to send in questions. I'll ask another one in the interim. Sam, one of the things that happened here in California is that there was an attempt to pass some legislation at the state level, which would have made clearer that people can't camp, obstruct, and damage flood control facilities that are part of what we call the state plan of flood control. Those are federally authorized flood control facilities here in the Central Valley. That statute or that bill started moving its way through the legislature And ultimately, it stopped last year because of objections from the homeless advocates here in California. And there were a few different issues that were raised. One was the belongings of the individuals and what would happen to those belongings. Secondly, one of the strong positions taken against our bill was that Boise makes it illegal to criminalize homelessness, and we were doing just that. And that we couldn't have a bill without an affirmative place for people to move, and it was the obligation of these special districts, these flood control districts, to provide space. So I think we've already talked about that legally, that's really not what Boise said. But I'm curious if you have a perspective more on the policy and political side about what the most effective responses would be to homeless advocates. Again, our goal isn't to leave the homeless as homeless without support, but many of the people on this call are not parts of cities and counties. They don't have a social services agenda. They have a limited budget, and it's often limited just to flood protection. Curious if you have any thoughts on the right political or policy response.
This is a difficult area because I think it gets a little bit distorted by the media. In our appeal to the Supreme Court from the Ninth Circuit's decision, we had, it was I think 21 or 22 amicus briefs that were filed, not from, NIMBYs and things like that. They were filed by the Union Rescue Mission in Skid Row. They were filed by homeless organizations, homeless outreach organizations, and public health organizations in San Francisco and around the country. And as I mentioned at the top, really the people who are hurt in these encampments are the people who are there, many of whom have mental health issues, many of whom have addiction issues, and many of whom just don't have anywhere else to go. And trying to get people out of these dense encampments is not really about trying to get them out of our municipalities, but trying to get them into a place where it's safe for them as well as for the public. I think on the, understanding that not everybody here has a social, services department to do this outreach, I think the real focus should be on, well, one, let me step back, no affirmative obligation to provide a shelter or a place for people to go as long as there is somewhere in the public for them to go. And then on the media and the messaging front or the PR side, I think to focus on the risks to the public and the risks to the homeless communities themselves. I can direct you to all the briefs written by these homeless outreach organizations, critical of the decision in the Ninth Circuit. But again, allowing these congregations of homeless, these really encampments, and we should distinguish between homeless people and homeless encampments where they tend to spread very rapidly, is a danger to them as well. And we chronicle a number of murders, sexual assaults. There was in Portland, I think, or maybe in Seattle, there was a case of a number of firearms and a few pounds of drugs that were taken out of a tent where a gang pretty much has set up operations within one of these encampments. So they're not pleasant places, of course. They're not safe places for the people who are residing there. And so bringing that home is, I think, critical.
So there's a few more questions that have showed up in the chat. Two of them deal specifically with potential liability of government agencies, and I'm a little reticent to dive into that because, as we've indicated, you and I don't know what the particular laws are in the particular states of the folks who are asking the question. But there is a question that doesn't get to liability, and maybe this will be the final question we'll do, and then we'll turn it back over to the panel. And Sam, I really appreciate your time here today. The question is a little bit of prognostication, and maybe it's not exactly for lawyers, but I think you have a lot of experience in this area, and so I'd appreciate your perspective. Kevin writes, what's your best guess as to the likely resolution of this issue? Where's the sweet spot that we're going to land? Are we going to end up with designated housing, established camping areas that the government provides, armoring levies to allow homeless to continue to stay on those levies? What do you think the sweet spot is for trying to resolve this issue?
I think that's going to change based on where you're at. A place like the city of Los Angeles, where I live, you're probably going to want to look at designated camping areas as they've already started to set up. They have the infrastructure and the police force to kind of enforce move-along orders and prohibitions on camping in dangerous areas, places like levees where they can do harm to public facilities. In areas where there's less of a police force or less of a sort of fixed infrastructure, it might be better to shore up these places where the homeless might end up camping. And so it's not a one-size-fits-all thing. And that's the thing that gets a little bit dangerous with decisions like Martin, because it leans us toward a one-size-fits-all solution to the homelessness issue that might be practical in San Francisco, New York, LA, but won't in many of the smaller towns across the country. There's plenty of latitude, though, as I said, throughout to continue to experiment as long as you're staying away from these broad categorical prohibitions.
And why don't you just wrap up by running through again the three prohibitions that you read out of the case? Do you recall?
Yeah, so I think first, you cannot have any strict categorical prohibitions on camping within a municipality. You should stay away from anything that says you can't camp outside anywhere within our jurisdiction. Two, I would stay away from imposing criminal penalties. Now, that's not necessarily going to be struck down if there are places where people can camp, but you're just going to get into trouble. It's going to make it be a harder hill to climb. A lot of courts have thrown out cases brought under Martin where there is no threat of criminal enforcement at all because the Eighth Amendment simply doesn't apply in those cases. And I think third is clear and consistent enforcement. So there's not concerns about selective enforcement or targeting certain groups, or in the alternative, trying to essentially push the homeless out of your jurisdiction entirely.
I appreciate you running through those last three. Another question came in from Mark Strudley asking about whether X is allowed. In his example, it was the ability to move homeless without the burden of having to calculate housing availability. And I think it's just important for everyone to remember that courts rarely say what is allowed. What they're really good at saying is what's not allowed. And that's because of a whole jurisprudence discussion about you can only actually resolve the case or controversy before the court. So courts can't say, well, you could do this. And so that's one of the challenges in City of Boise versus Martin, is it has these very clear rules, as I think Sam has articulated, about the three things you can't do. But beyond that, it's really an open choice for agencies to handle unless and until someone takes the agency back to court and the court says, nope, that's also not allowed. So my advice to all of you, and I suspect Sam would agree with this, is act reasonably, act thoughtfully, make sure you have a clear record. Try to make sure, to the extent you're adopting an ordinance, that is a compassionate ordinance, that it does not criminalize, not criminalize at all, that it addresses conduct, right, not status. And so those would be my final words. Sam, any final words you have for the group?
Yeah, I guess just in response to that last question, that the City of Boise case spoke in terms of shelter space. They did not impose any affirmative obligation to construct or to offer shelter space, indoor shelter space. And the reason they spoke about available beds was because the ordinances prohibited all camping outside. I think if they had designated areas where you could camp outside, you don't get into that issue of shelter beds. It's only when you want to say nowhere outside, and by practical implication, nowhere inside either, that you run into problems under that case. But yeah, this is an issue that has gotten a lot of attention. It's a real social problem. It requires solutions that go beyond the law. And people like you in your positions to be trying to address it as best you can. I don't think there's a one-size-fits-all answer. It'll present a challenge going forward, but one that I think we're already seeing a lot of municipalities respond to in interesting and creative and promising ways.
Well, thank you again for joining us this morning. For anyone who wishes to reach out to Sam, he is at Gibson Dunn in Los Angeles. I'm sure if you Google his name and Gibson Dunn, you will easily find his profile. Again, I'm Scott Shapiro, happy to have participated today, and I'm going to hand this over to Steve Graham as Sam and I turn off our cameras and our microphones.
Thank you.
Good morning. Thank you, Scott. My name's Steve Graham. I'm the interim general manager of the San Antonio River Authority here in Texas. You heard a great dialogue about some legal precedents in the issue of homeless encampments. We're going to pivot a little bit and start talking to practitioners who are actually dealing with these situations in their jurisdictions. We have Dave Bennett's, we have Darren Sue and Jennifer Codian, and I'm going to ask them to turn on their cameras. Each of them, I'll call them out in order.